case briefs, and so much more. LSData's got what you're looking for.
In a seminal case that pivots on the issue of student loans and bankruptcy, numerous individuals leveraged a legislative loophole to petition for their student loan debts to be discharged. Interestingly, this legal controversy emerged not because of existing laws, but due to the temporary absence of one. A relevant law that deemed student loans non-dischargeable in bankruptcy was repealed, creating an 11-month window before its replacement came into effect. The tangle of 21 voluntary bankruptcy petitions, all related to educational debts either owed to or guaranteed by the New York State Higher Education Services Corporation and reinsured by the U.S. Office of Education, presented a unique conundrum. At the heart of this controversy was the repealed provision that allowed for the discharge of a loan after a 5-year period from the initiation of the loan repayment or under conditions of undue hardship. Initially, the bankruptcy court permitted the discharge of these student loans during the legislative gap, a decision that the district court later affirmed. However, the Court of Appeals took a different stand, stating that decisions allowing the discharge of student loans during this period were incorrect. In the tug-of-war between strict interpretation and inferred intention, the Court of Appeals sided with the latter. They contended that Congress merely made an oversight by not synchronizing the repeal and replacement dates of the statutes, and it never intended for an 11-month hiatus where student loans could be arbitrarily discharged. The court's stance was bolstered by the savings clause in the new law, which safeguarded the rights of parties in actions commenced prior to the law's effective date. Reversing the decisions of the lower courts, the Court of Appeals held that interpreting the new law to allow the discharge of student loans during the brief gap contradicted Congress's clear intention and could potentially harm the substantive rights of appellants. The court remanded the petitions back to the bankruptcy court, emphasizing that the law should not be interpreted merely to its letter, but in a manner that respected its manifest purpose, an approach that echoes the principles acknowledged in judicial precedents such as Peter Pan Fabrics, Inc. v. Weiner Corp., and Federal Deposit Insurance Corps v. Tremaine.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.